Hello, and welcome to I2I Workplace's Harassment Prevention Training Program for 2023. This training is part of your organization's mandated harassment prevention program. Many employers have put harassment prevention training on the back burner, understandably prioritizing other issues during the pandemic. But many states mandate the training, and since 1998, the EEOC has strongly encouraged all employers to conduct training in order to demonstrate that they took reasonable care to prevent and respond to harassment in the workplace. Your employer has made the wise decision to enforce its harassment prevention and response program and is mandating this training. Many of you have been through harassment training before, unless you are new to the workforce or worked for a smaller-sized organization. This introduction to harassment prevention training will cover some of the updates that have occurred over the past couple years. Harassment in the news and other media, government developments on the federal and state level, and then issues regarding work from home or remote work that have changed the legal landscape. Sexual harassment continues to be in the news as high-profile people ruin their reputations and careers and force others to put up with their degrading behavior. Countless politicians have had their reputations crushed with harassment allegations, including Governor Cuomo. He is one of a long list of politicians that had to resign from elected positions due to allegations of inappropriate behavior. But it's also entertainers, sports figures, and business executives who have had to resign or be fired for harassment. These are just a few of the many people having to answer for their bad behavior, and their reputations have suffered. That occurs in every industry, from universities to technology to government. Also, there's been an increased awareness of offensive terminology. For example, in song lyrics, the song lyrics continue to push the envelope of what is appropriate. Even warnings about explicit language are insufficient to be appropriate in the workplace. However, many artists are becoming aware that their words matter. For example, Beyoncé and Lizzo both removed offensive terms from released songs. Certainly, you may listen to whatever music you want on your own time, but ensure that your musical choices do not reflect poorly on you in the workplace. Also regarding terminology, Stanford University's IT department recently published a guide to the elimination of harmful language, which lists terminology that aims to eliminate language that may be racist, violent, or biased against disability, ethnicity, or gender in the university's publications and websites. Now, this is just within the university, and there has been some pushback about the publication, but clearly words matter, and there is an increased awareness of the need to use only appropriate terminology that will not offend anyone or any group of people. The topic of workplace harassment has always been included in classics such as 9 to 5, Love Actually, and Bridget Jones. And the new 2022 movie, She Said, about the Harvey Weinstein's sexual assaults and rapes. Another movie highlighted the topic of sexual harassment in the 2019 blockbuster called Bombshell, which was about Roger Ailes and Fox Network. Ailes settled Gretchen Carlson's lawsuit for $20 million, but her agreement contained a non-disclosure agreement. Fox eventually paid out a total of $50 million for other women's claims of sexual harassment. And this issue was addressed with Congress. Due to this case and many other examples, a new law was passed. On March 3, 2022, President Biden signed into law the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. The new law amends the existing Federal Arbitration Act, which prohibits employers from requiring employees to resolve sexual harassment and sexual assault claims through private arbitration unless their decision is voluntary. The Act prevents people subjected to assault or harassment at work from being locked into mandatory arbitration, meaning claims may be taken to federal and state courts. In addition, employees will be able to bring class action lawsuits against employers. There has also been activity on the state level. Many states are expanding rights for employees and mandating training and education, posters, brochures, and other requirements. More than half the states have unique requirements in terms of content, length, frequency, and other elements. Even if your state does not have a specific mandate, on the national level, the EEOC strongly encourages all employers to conduct training. And Title VII provisions extend to employees of U.S. operations. So getting consistency across the globe is important. In other news, the pandemic continues to disrupt the workplace. With the pandemic physically separating employees from their colleagues and clients, one would expect that incidents of workplace harassment might be fewer. However, that was far from the case. 2 recent surveys reported that incidences actually increased. For example, a survey from Project Include noted that over the pandemic, 25% of respondents to the survey experienced an increase in gender-based harassment. 10% experienced an increase in race and ethnicity-based hostility. And 23% of respondents who were 50 years or older experienced increased age-based harassment or hostility. Another survey conducted by Deloitte found that 52% of women have experienced some form of harassment or microaggression in the past year. Returning to the office provides an opportunity to recalibrate behavior to ensure that people are relearning appropriate norms. And if your workplace is still remote, a manager or supervisor could reiterate standards in a video call and certainly intervene if inappropriate comments or interactions are noted. You should know that there are many people willing to listen to any complaint you have. Any manager or supervisor, senior manager, or HR representative. With a more casual work environment from work from home, it seems that some behavior may be swept downward in the vortex. Interactions over the computer or phone are usually unmonitored and may allow for more intimate conversations that get out of hand. No one can overhear or observe inappropriate behavior. And the pandemic conditions added to the stress employees felt, making them more angry or likely to snap, or feeling overwhelmed, leading to bad decisions or reckless behavior. The more casual workplace and a blurring of work and home behaviors might negatively impact an employee's level of professionalism. Here are some examples of what could be construed as virtual harassment. Sexual jokes sent via Slack, instant messaging, or a video conference chat, sexual images or videos, or links to inappropriate websites, screenshotting images of a coworker and posting on social media, starting unwanted online conversations of a sexual nature, or sexually intimidating a fellow employee or client, making derogatory comments about someone and their body or gender in meetings or in chats. And don't forget, this could be not just about sexual commentary, but also commentary regarding race, gender, sexual orientation or gender expression, disability, age, or any other protected category. Certainly, everyone needs to be aware of their online behavior and ensure that it's always respectful and professional. This training will discuss 3 sections: legal, behavioral, and practical issues about harassment in the workplace. After each section, there are a few test questions, along with some case scenarios to illustrate common examples. At the end, you will be asked additional test questions, and if you pass 80% correct, you will receive a certificate of completion emailed back to you, and you will be provided with the opportunity to ask any questions about the content at the end. Thank you for your attention to this important training topic. Legal issues. In this section, we'll talk about legal issues and the many laws that provide you with rights and responsibilities. We'll discuss the legal issues of discrimination, harassment, retaliation, and abusive conduct, otherwise known as bullying, in the workplace. There are both federal and state laws. For federal laws, there are the U.S. Supreme Court decisions and U.S. EEOC guidance. And the EEOC strongly encourages employers to do harassment prevention training. There are also state-specific laws. Some states have mandatory training requirements, such as California, Illinois, and New York. In other states, the training is recommended or only required for certain segments of employers. Each state also has posters that are specifically required to be posted. In 1998, the U.S. Supreme Court decided two landmark cases that strongly encourage employers to conduct harassment prevention training. Those cases were Burlington Industries versus Ellerth and Farragher versus the City of Boca Raton. In both of those cases, the employer was able to demonstrate what's called the affirmative defense, because they took reasonable care to prevent and respond to the harassment that occurred. In both of those cases, the employees unreasonably failed to take advantage of any preventative or corrective opportunities available to them. Those two cases demonstrate that employers should take proactive steps to avoid liability. In 1998, the EEOC provided a three-pronged approach as guidance for employers for preventing harassment. First, employers should adopt specific policies about sexual harassment, including a definition of harassment with real-life examples, language about non-retaliation for those who come forward with complaints, and also a statement that sexual harassment will lead to disciplinary action up to and including termination. For complaint handling, complaints of sexual harassment must be promptly, vigorously, and honestly investigated, and valid complaints must be remedied. Employees must be offered multiple avenues of complaint, meaning an HR person, supervisor, manager, or ombudsperson. And training. Employers should consider training all employees, from the CEO to frontline employees, to be sensitive to issues of sexual harassment. Federal law establishes various protections for groups of employees. These are called protected categories. Here's a list of the federal protections that are afforded to employees. The major law dealing with discrimination and harassment on the federal level is Title VII of the Civil Rights Act of 1964. This law prohibits discrimination and harassment based on characteristics such as race, sex, color, religion, national origin, ethnicity, and ancestry. A recent U.S. Supreme Court decision determined that sexual orientation, gender identity, and gender expression are also protected categories. Another protected category are employees and applicants over the age of 40 under the Age Discrimination in Employment Act. And pregnancy and related medical conditions are protected under the Pregnancy Discrimination Act. Military status is a protected category under the Vietnam-era Veterans Readjustment and Assistance Act, and USERRA, and disability, either a physical or mental disability that impacts a major life function, is protected under the Americans with Disabilities Act. Immigration status is protected under the Immigration Reform and Control Act, and genetic characteristics are protected under the Genetic Information Non-Discrimination Act. With regard to federal discrimination law, it prohibits discrimination and harassment based on protected categories. This comes up in terms of pre-employment inquiries. It restricts the kinds of questions that can be asked, so you cannot inquire about protected categories or make hiring decisions based on that information. It also affects promotional opportunities in the organization, as well as all terms and conditions of employment. This would include compensation, benefits, training opportunities, etc. The discrimination laws also require religious accommodation and accommodation for disability, military leave, and family leave. And Title VII applies to locations with operations outside of the United States. In addition to the federal protections, many states go further and have passed laws to protect other groups of people. Some examples of protected categories in other states are marital status, medical condition, political affiliation or activities, status as a victim of domestic violence, assault, or stalking, and if someone requests leave for family care, pregnancy, or an employee's own serious medical condition. But you will want to confirm which categories are protected in your state, and that information is generally found on your employer's policy or on the poster for your specific state's fair employment practices or human rights law. To summarize the legal issues section, remember that you have rights in the workplace, certainly, but you also have responsibilities. These laws protect you on both the federal and state level. That concludes the preview portion of the training. If you'd like to see the next two sections on behavioral and practical issues, please visit our website. We provide certificates of completion, training records, and many resources to help you comply with the regulations on the federal and state level. We have state-specific versions for California, Delaware, Connecticut, Illinois, Massachusetts, Michigan, New York, Washington, as well as national and international versions. We also provide the active bystander intervention training in our training package for one low price. Visit i2iworkplace.com. We provide smart, high-value HR solutions.